Good morning. Welcome to today's program and welcome to today's author scholars, Brad Snyder and Jeff Rosen. They will be in conversation about Brad's recent book, Democratic Justice, about the many lives of Felix Frankfurter, a history that illuminates our own time. This program is co-sponsored by Addis Israel in Washington, D.C. and Congregation Bethel in Bethesda, Maryland. We're grateful for the loyal support of the Addis Israel Sisterhood, Women of Bethel, Library Committee, and Men's Club. On behalf of those groups, we welcome you. I'm Robin Jacobson, the librarian at Addis Israel. I also facilitate Bethel's book club together with Marge London, who's here today too. And let me bring Marge into the spotlight. So here's Marge. And you will see that in honor of today's program and Justice Felix Frankfurter, Marge and I chose Zoom backgrounds of places important to Frankfurter. I'm in front of the U.S. Supreme Court, and Marge is greeting you from Felix Frankfurter's beloved Harvard Law School, where he taught for 25 years. Before we introduce our guests, let me announce the next Zoom program. On Sunday, April 16th at 11 a.m. Eastern Time, we will welcome Jenna Rose Nethercott to talk about her enchanting novel. Thistlefoot was a finalist for the 2023 Jewish Fiction Award and one of NPR's and the Wall Street Journal's best books of the year. This novel is about two siblings who receive an unusual inheritance from Ukraine. This is a setting that makes the novel especially relevant now. The event is in the chat box with its registration link. And now, Marge and I will share the honor of introducing our distinguished guests. So please go ahead, Marge.
Okay, I am delighted to introduce you to Professor Brad Snyder, who teaches constitutional law, constitutional history, and sports law at Georgetown Law School. He is the author of Democratic Justice, Felix Frankfurter, the Supreme Court, and the Making of the Liberal Establishment, the subject of today's conversation. You can purchase that book through a link in the chat. Brad is also the author of The House of Truth, a Washington political salon, and the Foundations of American Liberalism, in which a young Felix Frankfurter plays a role. On top of that, Brad has also written two critically acclaimed books about baseball. Brad is a graduate of Duke University and Yale Law School. We are proud to claim Brad as an extended member of Bethel's family. His brother, Ivan Snyder, is a Betheller, currently serving on Bethel's board.
And now I have the pleasure and honor of introducing our second scholar, Jeffrey Rosen. Jeff is the president and the CEO of the National Constitution Center in Philadelphia. He is also a professor at George Washington University Law School and a contributing editor of The Atlantic. Jeff has been called the nation's most widely read and influential legal commentator. His essays and commentaries have appeared in the New York Times Magazine, on National Public Radio, in the New Republic, where he was the legal affairs editor, and the New Yorker, where he was a staff writer. His review of Brad's book appeared in the New York Times Book Review. We sent early registrants a link to that review in this week's bonus drop. Jeff is the author of multiple books, including most recently Conversations with RBG, Ruth Bader Ginsburg on Life, Love, Liberty, and Law. His other books include Louis Brandeis, American Prophet, which Jeff introduced at a wonderful Addis Israel program. Some of you were there. Jeff is a graduate of Harvard College, Oxford University, and like Brad, Yale Law School. Beyond these affiliations, Jeff is part of Addis Israel's family. Many of us fondly remember his twin sons, Hugo and Sebastian, as small boys in our school. We are beyond thrilled to have both Brad and Jeff with us today. And now for some program details. While Brad and Jeff converse, you are welcome to reserve a place in line to ask a question yourself. You can do this by raising your electronic hand, and we will turn to your questions towards the end of the program during the Q&A period. That portion of the program will not be recorded, so no need to feel shy. To raise your electronic hand, click on the button labeled Reactions, then choose the option Raise Hand. And now, with great pleasure, I'm going to bring our two scholars on the stage. So that's Jeff, and that's Brad. And I think we're good. So there you are. This is so exciting. Welcome and thank you so much for coming and letting us listen in to your conversation about Felix Frankfurter. I'm going to stay backstage and turn the program over to you.
Thank you so much, Robin and Marge, and good morning, Addis and Bethel friends. It is an honor to be with you and to have the incredible opportunity to discuss with Brad Snyder the life and legacy of Felix Frankfurter. Brad, good morning. It's so great to be with you. Congratulations on your book, which has been rightly acclaimed as the definitive biography of Justice Frankfurter. And this is such a meaningful opportunity to talk with you about Justice Frankfurter's legacy. As you say in the book, Felix Frankfurter, who was considered during his lifetime and at the time of his appointment to the court a hero of progressive liberalism, has gone out of fashion in recent years. His principled devotion to judicial restraint, his extremely limited and democratic view of the judicial role, which essentially held that judges should almost never strike down laws at all unless they were patently, palpably, unquestionably unconstitutional, was questioned both by progressives who felt that he let them down by not standing up enough for free speech and equality, and by conservatives who came to like the idea of using the courts to strike down laws when they challenged individual rights. So this is a great opportunity to discuss what to make of Justice Frankfurter today. I'll begin with the obvious question, which you introduced in your book. Why did you choose to write about Frankfurter, and why do you think that his legacy is uniquely relevant today?
Well, first, Jeff, I'll let me just do some thank yous of my own. Thanks to Marge and Robin and Addis and Bethel, and lastly, thanks to you. You encouraged me when I was a real young scholar. When I wrote a law review article about one of Frankfurter's best students, Henry Friendly, and I'll never forget that. And I'll, your encouragement meant a lot to me at that time when I was early in my law professor career, and I really appreciate you taking the time to do this today. As for Frankfurter's sort of legacy and why I wrote the book, I came out of law school shortly after Bush versus Gore, which when the Supreme Court stopped Florida's recount of its electors, and shortly before I entered law school, they decided a case called City of Bernie versus Flores, where the Supreme Court really limited Congress's power to enforce the 14th Amendment. And I became very disillusioned with the Supreme Court of the United States. And so those two cases really had a huge impact on me. And I was writing an article about the Rosenberg case, the case of convicted atomic spies, Julius and Ethel Rosenberg. And I was really struck by both Felix Frankfurter and Hugo Black's insistence that the court take the case on the merits. The court never took the case on the merits. They had heard an 11th hour appeal. And I was really struck. Frankfurter wrote this dissent after the Rosenbergs had been executed, and he was really writing for his law clerks and his law students who were disillusioned with the Supreme Court of the United States, and was telling them not to lose faith in the rule of law. And I said, that dissent really spoke to me, and Frankfurter's role throughout that case really spoke to me. And I said, I really need to learn about this person who in law school was really sort of vilified by my professors. He was viewed as sort of the villain of the Warren Court, sort of the one who was supposed to be the liberal leader of the Warren Court, but turned out to be this sort of conservative. And as I started researching his career more and more, I thought that wasn't entirely accurate. And the great thing about writing history, as you know, Jeff, from writing about Brandeis, is you have different perspectives on people depending on when you write about them. And I think in this age of judicial supremacy, right? This age of where the Supreme Court insists on having the last word on the Constitution and sort of strikes down federal laws sort of with a drop of a hat without ever really thinking about it in a way that would have been unheard of at the founding, and even in Frankfurter's time would have produced a lot of outcry. I think Frankfurter's ideas about the Supreme Court's role in a democracy have more importance now than ever before.
Wonderful. So interesting to hear that it was cases like City of Bernie and Bush v. Gore that persuaded you to resurrect this tradition of liberal restraint, as well as faith in the law in the Rosenberg case. You know, I want to go through Frankfurter's biography, his legacy, and the book, but let me just jump in and put my cards on the table, tell you where I'm at. As you know, I spent more than 20 years as legal affairs editor of the New Republic, in the tradition that Frankfurter had started when he was at the New Republic, of liberal judicial restraint, arguing that judges should rarely strike down laws and that you should have a very limited judicial role. And that tradition was carried on by Frankfurter's student Alexander Bickel. I wrote a lot of pieces about that. But for me, Bush v. Gore was a turning point. It really suggested that neither conservatives nor liberals were interested in the Frankfurter view of a very limited judicial role. And both sides nowadays want to use the court to strike down stuff they don't like. And essentially, there's not a single justice on the current court in the Frankfurter tradition. So with that in mind, is your effort to resurrect Frankfurter's vision an essentially academic exercise, or do you think that the justices really should be persuaded to resurrect it, even though they're not close to there at the moment?
Well, I think that's a really good insight about the left. You know, this isn't just a left-right issue. I think the left really aggrandized the court's power more than the right did. I think, you know, I've written about this at the Warren Court, in particular in cases where they might have been right on the merits, such as Cooper versus Aaron, which was the Little Rock school crisis, and Baker versus Carr about Tennessee's failure to reapportion. You know, it was the left that was saying the Supreme Court is the supreme interpreter of the Constitution, or in Baker versus Carr, they said, you know, the Supreme Court's the ultimate constitutional interpreter. I think our ideas are similar. You know, I was preaching to my law students, you know, in the 2000s that, you know, the left seems to worship at the altar of Justice Kennedy, and that's not a constitutional theory. That's just, you know, a political tactic. And they were sort of saying, well, what does Justice Kennedy think about, you know, gay marriage, capital punishment, you know, whatever you have. And that's just that both sides have bought in to this idea of sort of outsourcing our democracy to the Supreme Court of the United States, where I think I differ with you a little slightly. And I'm just going to, I have a tremendous amount of respect for all of your experience writing about the court. I would say Justice Kagan has some aspects of Frankfurter's judicial restraint in the fact that she's really concerned with following precedent. And I think one of the ways that Frankfurter tried to cabin the Supreme Court's power and to sort of slow the pace of the Warren Court's change was to urge his colleagues to follow precedent and uphold precedent, even if they didn't always agree with it. And I think she's got some similarities to him in that regard. But I agree with you that there's no one totally like him in terms of being deferential to particularly to federal power the way he was.
That's such an important point, Brad, and you're absolutely right that it really was Frankfurter's devotion to precedent and incrementalism that was the core of his philosophy, and that's the central division between the liberals and conservatives on the court today. On the left, you have the liberals, certainly including Justices Kagan, Jackson, and Sotomayor, who are insisting that precedent should have weight, and on the right, a vision that text, history, and tradition are the most important touchstones, and that precedent should have much less weight than it did at any time since, as it happens, the Warren era, when the court was overturning a lot of conservative precedents in a liberal direction. So that's the central distinction. All right, then let's focus now. Again, I know we're just jumping right in. we both share a sympathy. We're both inclined to embrace a vision of Frankfurter's view. Let's just ask how well he did, how appealing it was, how principled he was during his time on the court. And just for the sake of argument, let me make the case against Frankfurter that his devotion to precedent and judicial minimalism was so extreme that he was transparently wrong, even in cases where the history and text counseled intervention, most notably the free speech cases. And so talk about that transition from Gobaitis to Barnett, where Frankfurter first insisting on upholding mandatory flag salutes, then lost the court when it took the other side. You say that it was partly his devotion to FDR as a wartime leader and his personal allegiance to strong executive power that might lead him to take that position. Just to use that as a touchstone, how can we reconcile his performance there with a sympathetic verdict on Frankfurter?
Well, so, Minor Trill versus Gobaitis was about two children of Jehovah's Witnesses who were compelled to give a stiff-armed salute to the flag in addition to saying the Pledge of Allegiance, which, with the rise of the Nazis is really abhorrent, right? And Frankfurter wrote and was a new justice. He was assigned the majority opinion by then Chief Justice Hughes based on his comments at conference. And I can guess they went something like this, Jeff. We don't know what exactly was said, but I can guess something like this. Frankfurter came to this country at 11 years old. He didn't speak a word of English. He had never heard one spoken. And he credits his first teacher at PS 25 in Lower Manhattan with threatening his fellow students. He was living in a German-speaking neighborhood at a school with many German immigrants in it. His teacher threatened them with corporal punishment if they spoke to Frankfurter in his native tongue, which was German, and he quickly learned English to the point where when he graduated, he was giving a speech, about American history, at his graduation from elementary school, and then he, thrives at CCNY and their combined public high school and college program. So, Frankfurter really believed, and before finishing first in his class at Harvard Law School at age 23, when he quickly becomes on a first name basis with former President Theodore Roosevelt. That's an incredible rise, right, from 11, to his mid 20s. And I think Frankfurter credits it to public education and to the sort of power that public education has to mold students and to inculcate a kind of civic education in them and civic pride. And so if you think about it, I think Frankfurter might still be on the right side of those cases, because although the flag salute and the Jehovah's Witnesses are ugly facts, if you change the facts to teaching things like the civil rights movement, or if you change the fact to teaching creationism instead of evolution instead of creationism, I think Frankfurter's saying you can't use the First Amendment to create as applied challenges, right, which are individual challenges to the way states are running their school systems, because you'll undermine state education, which plays such an important civic education function. And I think that has some purchase today when we have cases currently pending before the Supreme Court of the United States, where we have a Colorado web designer who wants to opt out of the state's anti-discrimination laws because of her religious beliefs. Now, I know Gobaitis was a free speech claim, but the West Virginia versus Barnett, which is where the court reversed Minersville versus Gobaitis a few years later, as you know, Jeff, was a compelled speech claim. And so those, West Virginia Barnett versus Barnett is the first case cited by religious people who want to opt out of laws of general applicability. So I think if Frankfurter were here with us, he would argue strenuously that he was right. That the First Amendment should not be used to tear down our anti-discrimination laws, to tear down our healthcare laws, and to tear down our public education system. So I think from his perspective, that's what he was after.
Fascinating defense of Frankfurter's position. It evokes Justice Kagan's criticisms of the majority of the court for weaponizing the First Amendment, as she says, to create religious exemptions and protections for corporate speech, and it's a powerful case. You've mentioned his Jewish background. Around the time that he decided go Bitus, you note that Frankfurter courageously gave a speech attacking the Neutrality Act and criticizing a speech of Hitler attacking free speech and the press. Some of the most wrenching moments of your biography are the vicious anti-Semitic attacks on Frankfurter, including a Nazi newspaper caption on his nomination that said that FDR was making himself a handyman for world Jewry to win a third term. Tell us about Frankfurter's Jewish background, his education. To what degree did he identify as a Jew? He noted it in Gobitis, and how important was his Jewish upbringing in his life?
Well, I think it was important. I mean, he left the synagogue at age 15 and never went back. He thought that it would be hypocritical for him to attend synagogue when he didn't believe in God, but that didn't mean that culturally he really valued his Jewish background. And like Louis Brandeis, who you wrote about so beautifully in your book, Jeff, he was a big Zionist. At a time where there weren't a lot of Zionists. And so neither Brandeis nor Frankfurter, as you know, were religious, but they really believed that the Jewish people deserved a homeland in Palestine, and they spent most of their lives trying to achieve that goal. Frankfurter experienced anti-Semitism all along his career, but he wasn't somebody who was willing to make a big deal out of it. During Brandeis's confirmation to the court, Jeff, as you know, was very protracted. It was a huge fight. And Frankfurter and Walter Lippmann were writing editorials in the New Republic, the publication you wrote for, and they were in charge of taking the lead on defending the Brandeis nomination. And they decided very early on not to make anti-Semitism a factor in that confirmation hearing. And I think that's true of Frankfurter's life. Right, he was first in his class at Harvard Law School, and he could not get a job at a Wall Street law firm because Wall Street law firms just didn't hire Jews. But he eventually landed one and left after 3 months to go work in the prosecutor's office, which for Henry Stimson, and that really catapulted him into friendships with people like Theodore Roosevelt, into becoming a Washington insider, and then he becomes a confidant of Franklin Roosevelt, and the rest, as they say, is history. I think what really upset him and Brandeis more than anything, Jeff, and I learned this from writing this book, were German Jews from New York who they felt like were cowards. And one of the shocking things about Frankfurter's nomination to the court in 1939 by Roosevelt was the opposition of Arthur Sulzberger and Henry Morgenthau Sr. that they conveyed to FDR. Don't nominate Frankfurter to the court. It will stir up too much anti-Semitism with the rise of Nazism, and Jews don't need the kind of backlash that would occur from Frankfurter's nomination. And that kind of really blew my doors off, right? I couldn't kind of wrap my head around that basis of opposition to Frankfurter's nomination. But I think there was a real divide, both on Zionism and other things among Eastern European Jews and German Jews. It was shocking to me. But I just don't think Frankfurter let anti-Semitism stand in his way. And for example, when Hugo Black was nominated to the Supreme Court, this was another fascinating thing, and I'm thinking about writing a future project on Hugo Black. When Black's nominated to the court in 1937, before Frankfurter, he's Roosevelt's first nominee. After Black is confirmed, news stories come out that Hugo Black, when he was in Alabama, had been a member of the Ku Klux Klan. And everybody wrote Frankfurter about this. And Frankfurter said, I don't care. Right? He knew Black well enough to know that that may have been something that Black needed to do to get elected to the U.S. Senate from Alabama, but that wasn't who Hugo Black was in his heart. And he said, give Hugo Black a chance. He was a great New Deal senator, and he could be a great justice. And I think he thought, and I think he was correct on this, that both he and Hugo Black had learned the same lessons from the New Deal constitutional crisis and from Roosevelt's effort to pack the Supreme Court of the United States, that the court should cabin its power. Now, Frankfurter and Black had very different ways of doing that. Black tried to use the text and history, and Frankfurter tried to use kind of precedent and a kind of incrementalism, but I think their goals were the same. And both justices learned the same lessons from court packing, which was that the court had too much power in the mid-30s and needed to defer to the democratic political process in most instances.
That's such an interesting contrast between Black and Frankfurter. It'd be wonderful to have a future project with you on that. And as you say, the debate between Black and Frankfurter foreshadows the debate on the court today between the textualists who are now conservative and the defenders of precedent who are now liberal. In that sense, Black won the battle. What about the case that Black rather than Frankfurter was right? Frankfurter, after all, refused to acknowledge that the framers of the Constitution intended to incorporate the 14th, the Bill of Rights through the 14th Amendment. Black was a much more vigorous defender of civil liberties. What about the case made by the conservatives today against the liberals that the precedent position is ignoring the text and history of the Constitution?
Well, you know, I think Hugo Black was an absolute visionary when it came to applying the Bill of Rights to the states through the 14th Amendment. That Black just understood the history better than the rest of his colleagues. I just think you have to look at the state of historiography at the time that they were working in. Many of these justices came of age and were reading, you know, the Dunning School's view of Reconstruction, which was this Southern view of Reconstruction as a corrupt enterprise. And I think Frankfurter was trapped in the Dunning School, and I think Black, by virtue of his Alabama upbringing, knew that didn't ring true, and re-examined the historical sources on his own, and deserves a tremendous amount of credit for it. I just don't think they're mutually exclusive. I think Hugo and Frankfurter were teammates on a lot of really important cases, and I think that started in Rosenberg. But let's just talk about school desegregation, which to me is the most important moment in the Supreme Court, maybe in its entire history, but certainly in the 20th century. Brown versus Board of Education is a seminal moment for the Supreme Court. You know, Earl Warren was a new justice in the fall of 1953. He was a recess appointment who had not been confirmed by the Senate. He had no constitutional law experience whatsoever. And it was Hugo Black and Felix Frankfurter who were helping him navigate that case. In one of the neat things I found in researching the book were Earl Warren's daily calendars, which he would write down which justices visited him. And during that crucial period after Warren's confirmation until Brown versus Board of Education was decided on May 17th, 1954, Frankfurter visited Warren the most number of times during that period. I can't remember the exact number. I think it was 11 or 12, but Hugo Black was there right behind him at like 8 or 9, right? And to me, that was some circumstantial evidence that Black and Frankfurter were really helping Warren achieve a unanimous court in Brown. And I just think they were on the same side, right? They may have had different notions about how to get there, but they were on the same side. Same with many of the communist cases, the suspected communist cases in the 50s, right? Frankfurter was in the majority, not on all of them, not on Dennis versus the United States, which is the Smith Act case in 1951 or 52, but on many of the cases. Right, Red Monday in 1957, Frankfurter's in the majority when the court issues 4 cases siding with suspected communists. So I often think they're on the same side in this notion of Black and Frankfurter as antagonists or as scorpions. I think it's false. And so I just think it's a little bit overdrawn. And then when you look at the arc of Black's career after Frankfurter leaves the court, Hugo Black, you know, takes a little more conservative and cautious turn, right? You know, post 1964. So, you know, they have different ways of getting there. I think my response to you, this was a long-winded way of saying it, is I think you need text and history and precedent as well, and that they're all important virtues. And Black refocused us on text and history, and Frankfurter, focused us on precedent.
That's a great response. It reminds us of the partnership of Black and Frankfurter. And Jim Simon had a wonderful book from a couple of years ago about the antagonists, about Black and Frankfurter's rivalry. And it ends with this moving scene after a lifetime of rivalry. Black dies of a stroke in the hospital. Frankfurter hears this, and he says, "Oh, Black hears that Frankfurter's died." He says, "Oh, Felix is dead," and he weeps.
And
you mentioned
Jeff Black drives up from Florida he's in Florida when he hears the news. He immediately drives in the car and come up to Washington for Frankfurter's funeral. The other really moving story comes from Alex Bickle. And one of the neat things I found, Alex Bickle's probably Frankfurter's greatest law clerk. Jeff's predecessor writing in the New Republic. And Bickle died tragically of cancer at a very young age. And Joseph Lash, when he was editing Frankfurter's diaries, did an interview with Bickle right before Bickle died of cancer. And I found Joe Lash's notes of that interview at the FDR library. And it was it was almost like a seance where I could summon Bickle from the grave about Frankfurter. And one of the things Bickle talked about was driving Frankfurter to Black's home in Alexandria after Black's wife had died, probably of a suicide, in 1952, and Bickle would wait outside while Frankfurter, who was very close to Josephine Black and to Black's children, this was a warm personal relationship that had its ups and downs ideologically, but ultimately I think they were on the same team.
That's amazing. And as our friends have just heard, the depth of your primary source research is remarkable and just illuminates so much. On that score, let's talk about Brown. As you say, it's Frankfurter's central legacy. He was absolutely played a crucial role in persuading Chief Justice Warren to delay so that public opinion, he hoped, could catch up to defending segregation. He was unique and in his time in defending the rights of African Americans, hired the first Black law clerk in Bill Coleman. Let me just, for the sake of argument, make the case against Frankfurter and Brown based on your own research and want to hear you defend it. You have this remarkable discovery that it was Warren wrote in his handwritten draft that racially segregated schools put the mark of inferiority on Black children, and Frankfurter proposed to change it to generates a feeling of inferiority in Black children. And those words, that segregation generates a feeling, Frankfurter's words, proved very controversial. Justice Thomas has criticized the court for focusing on feeling rather than objective stigma. And then it was Frankfurter who persuaded the court to embrace that with all deliberate speed language. Don't go too fast in implementing segregation so that public opinion could catch up. And finally, of course, he persuaded the court to wait nearly 13 years between Brown and Loving versus Virginia to strike down interracial marriage because he thought the country wasn't ready for it. So what about the argument that Frankfurter was too pragmatic in persuading the court to go slow and that it should have been more principled and struck down segregation immediately?
Well, I think those are great points, obviously. And I think I was fighting that view of Frankfurter, right? So I think you have to take kind of each one in turn. I think Frankfurter was really worried about in 1952 when Brown was first argued. I would really go back to Smith versus Allwright, which is a case I discuss at length in my book, which was about the all-white primary in Alabama. And that case was initially assigned to Felix Frankfurter to write the majority opinion. It would have required overruling one of the Supreme Court's precedents called Grovey versus Townsend. And that assignment was taken away from Frankfurter at the behest of his friend Robert Jackson, because Jackson thought that overturning Alabama's all-white primary would not go down easy in the South from a Jew from Boston. And so Stone took that assignment away and gave it to Stanley Reed, a Southerner from Kentucky. And Frankfurter didn't like the way that Stanley Reed had written the opinion, in Frankfurter's words, kind of pussyfooted around overturning the way he overturned Grovey versus Townsend. And Frankfurter wrote a draft concurrence, which he never published, and I wish he had. I published it in the book, it was saying, look, the 14th Amendment guarantees equal citizenship, and this is a denial of equal citizenship. And I think he was on the right track there. And so I think he always had that in mind, that notion in 44. And then, as you say, Bill Coleman was his law clerk in 1948 when the graduate school segregation cases came up. And I think Coleman had a profound influence on Frankfurter about the way to decide these cases. But he thought that Frankfurter thought Fred Vinson was not up to the task, and that Vinson's control of the court during the steel seizure case, where Truman had tried to seize the steel mills, was a disaster. In many ways, there's some evidence that Vinson may have been advising the Truman administration while this case was before the court. And so he had no regard, Frankfurter, had no regard for Vinson's ability to have a unanimous opinion and not have a multiplicity of concurrences and dissents. And so he was delaying, and particularly on the issue of the history of the 14th Amendment, where Alexander Bickel wrote an amazing memo that took that issue off the table. So I think you've got to look at what was going on at the time. And then I think Remedy's really hard. Hugo Black on Remedy at the time wanted to ignore the fact that Brown versus Board was a class action and just admit the named plaintiffs from the individual locales to the court. He said that at conference and afterwards. And that would have been a disaster. I mean, imagine that, Jeff, in the wake of the Little Rock Nine, having one student in each of these locales admitted. You would have gotten huge pushback and violent outbreaks all over the Deep South, in Virginia and South Carolina. And so I'm not sure there's a good answer on Remedy. And I agree that all deliberate speed was a really bad choice of words. But if you read that in the context of the opinion that he cited, it's a Holmes opinion called West Virginia versus Virginia. And Frankfurter's point in citing that language was how hard it is to get a state government to do something, right? For the Supreme Court to order a remedy to force a state to do something it doesn't want to do, right? I think in that case, it was West Virginia paying money back to the state of Virginia when it split off, right? I can't remember the exact details of that case, but I just think these are hard cases. And then if you go to name versus name in 1955, the Supreme Court was under attack after Brown versus Board of Education. I think Frankfurter was vindicated in ducking interracial marriage at that time. In 1956, we get the Southern Manifesto, which is when all the Southern members of Congress, except 3, including Lyndon Johnson, sign what is a very amazing legal document, which is a point-by-point refutation of Brown versus Board of Education based on text, history, structure, and precedent. It's a very impressive document written by really wise senators such as Sam Ervin. The court was really under attack. And so I think Frankfurter thought that, hey, we can take the heat from school desegregation, but I'm not sure we can, as a court, as an institution, can take on both school desegregation and interracial marriage and have all of the states ignore both of those decisions, and we'll look completely and utterly powerless or impotent. And so, I think some of his caution, right, and incrementalism was well served during a really tenuous period for the court institutionally.
Such a powerful defense. As you say, his central concern was protecting the institutional legitimacy of the court. Today, the heir to Frankfurter is Chief Justice Roberts, who in his Dobbs concurrence cited Frankfurter, who he called a thoughtful member of this court, on behalf of the idea that the court should preserve its legitimacy by respecting precedents, deciding cases narrowly rather than broadly, and generally deferring to the democratic process. As we both know, Roberts was alone in Dobbs. No liberal or conservative joined him. Does Frankfurter's experience suggest that Roberts was right, or does the fact that Dobbs is being accepted by America, even if it's unpopular, suggests that Frankfurter's idea that the court can only preserve its legitimacy by moving incrementally was wrong?
Yeah, I mean, I think Chief Justice Roberts is in a unique spot. The justice I would, and of course, Dobbs overturned Roe versus Wade for the non-lawyers in the group, and that's produced a lot of outcry. I don't know about you, Jeff. I really analogize Chief Justice Roberts to Charles Evans Hughes, who was a great Chief Justice, who had a lifetime of public law experiences, both as an associate justice, as Secretary of State, as a governor of New York, as a nearly president of the United States, who lost by a hair in 1916 to Woodrow Wilson. Hughes was really concerned with preserving the institutional legitimacy of the court. And I think Frankfurter, who was supposed to be a kind of antagonist toward Hughes, warmed toward Hughes and thought Hughes was the greatest Chief Justice he had ever known. And I think Roberts is trying to play this Chief Justice Hughes role of preserving the court's legitimacy. But I do not think Frankfurter would have joined Roberts's opinion, because again, I think Frankfurter was really concerned, as much as he did not like the idea of substantive due process, right, and would have rejected the kind of use of the due process clause of the 14th Amendment to read substantive rights into it. I think he would have said, look, this is a precedent that is, more than, nearly 60 years old. And we, the court, should not overturn it, given that people have ordered their lives around it. And so, again, I think Frankfurter would have followed precedent even if he did not like the reasoning on which Roe stood. And I particularly think he would have liked Planned Parenthood versus Casey, right, where the court wrote, as you know, that they really rejected Roe's reasoning, but upheld the precedent on sort of stare decisis grounds, which meant respect for precedent.
Absolutely fascinating. I'm going to ask a few more questions. Friends who are watching, perhaps you could try putting some questions in the chat, so Brad and I can pick among them. We'll have just a bit of time at the end, and that would be great to hear from you. Brad, you mentioned the fact that Frankfurter didn't respect Chief Justice Vinson. Of course, that's putting it generously. As one of your chapter heads suggests, Frankfurter made that notorious comment on the way home from Vinson's funeral, after Vinson had unexpectedly dropped out of a heart attack in the middle of the deliberations about Brown, that this is the first evidence that I've ever had that there was a God. He obviously had a acerbic tongue, to put it mildly. His wife memorably said in another quotation that really jumps out, can you imagine what it's like to live with someone who's never tired? My question to you is, did you end up liking Frankfurter? And if not, did the fact that he was somewhat exhausting, overconfident, cocksure of himself, limit his effectiveness on the court?
I think both are true, right? I think I ended up liking him. The one justice kind of in personality, but not in writing style, I would analogize him to is Justice Scalia, right? Sort of a very active questioner at oral argument, very smart, but also not somebody who influenced a lot of his colleagues, right? Wasn't really adept at getting votes for his point of view. And I think they share similarities, but I found Scalia in his own way to be incredibly charming and entertaining. And I think Frankfurter was someone that you would want to have a beer with, right? I just want to contrast him with Justice Douglas, who was notoriously misanthropic, in his personal relationships, and many of whose law clerks really despised him. But Frankfurter was beloved by the people who clerked for him, and I think he promoted their careers, right? When Bill Coleman finished in 1947, Frankfurter writes him a letter that says, I bet on you, right? And he encouraged Bill Coleman to become a judge. Now, Bill Coleman never became a judge, but he became the second Black member of a presidential cabinet when he became Ford's Secretary of Transportation. But Frankfurter bet on his law clerks, right? He was invested in them like he was invested in his former students at Harvard Law School. And I think that's a real important part of his legacy, too. So I agree, he alienated many of his colleagues. He was pedantic. He was irritating. at times, and he wore out his welcome with a lot of chief justices, including Chief Justice Warren. But I just think he was a force of nature and full of ideas and energy, and wrote 10 to 15 letters a day. And so in the end, I ended up liking him, but I saw him as a flawed justice, right? And I think no justice is without flaws, but Frankfurter had more than his share of flaws, and I could go through the list chapter and verse, but that doesn't mean that I didn't like him as a person. I thought he did a lot of heroic things throughout his life on and off the bench. And so I did end up liking him in the end.
Great. What do you make of Frankfurter's dissents in the major cases of the Warren Court? You note that it was he who famously warned against intrusions in the political thicket when the court began to regulate apportionment and gerrymandering. He dissented in many of the leading criminal procedure landmarks. These are all beloved by liberals as cornerstone precedents. Chief Justice Warren considered Baker v. Carr the most important case decided in his tenure. And Frankfurter was on the other side of many of those cases. Was he wrong or right, especially in light of what we're seeing on the court today?
So you mentioned Baker versus Carr, the criminal procedure cases. What was the last one, Jeff? I just missed the other one.
Baker v. Carr, Colgreve, all the apportionment cases.
Yeah. I mean, look, I think Frankfurter thought, just to turn our conversation back around all the way to the beginning, Jeff, Frankfurter believed in something called the political question doctrine, which is that the court should stay out of inherently political disputes that can't be resolved with a judicially manageable standard. That means that, the Supreme Court is not, a referee in a boxing ring that just raises one side's hand in victory. It has to explain its decisions and then provide some guidance for future legislators and future courts. And I think he saw reapportionment to be an inherently political question. And I don't know if I'm totally with him on the merits of Baker versus Carr. I was more with Bickel that Tennessee's failure to reapportion for 60 years was in and itself a kind of due process violation. But I am with Frankfurter that the Warren Court way overplayed its hand in Baker versus Carr. It eviscerated the political question doctrine, both in Baker versus Carr, and it called itself the ultimate constitutional interpreter. And then in a subsequent case, after Frankfurter left the court, in Powell versus McCormick, which was when, Chief Justice Warren really interfered with the House's decision not to sit Adam Clayton Powell. That evisceration of the political question doctrine, I think, leads us directly to a case like Bush versus Gore, when the Supreme Court of the United States is interfering with the 2000 election. So I'm kind of with Frankfurter on the political question doctrine as an important bulwark against judicial supremacy. There are a couple of really great questions in the chat. Jeff, can I mention a couple of them and try to answer them?
Please do. If you would maybe start with both Mark Lerner and Ellen Heller's questions about his response to the Holocaust.
Yeah, they're fantastic. So Mark Lerner asked about what was Frankfurter's reaction to information he received about the Holocaust. Frankfurter knew about Hitler's rise much earlier than just about anyone in the United States. He had spent Roosevelt's first year in office as the Eastman professor at Oxford. He was hearing a lot of things about Hitler's rise to power. He wrote an article warning against Hitler's rise to power in 1934 in Today magazine. He was actively involved in getting Jewish academics who were banned from German universities into the United States, into the New School. And he was also getting a lot of information out of Austria about Hitler's rise. And he was really dismayed by the dean of Harvard Law School getting an honorary degree from the German government. Roscoe Pound was a Nazi sympathizer, and they really broke over this. Other people like Walter Lippmann wrote columns that he thought were too sympathetic to the Nazis. So he was early on realized the threat that the Nazis posed. He saw World War II as a war to save civilization, and he was willing to do anything in his power, including violating separation of powers, by advising the War Department in the Roosevelt administration about how to defeat the Nazis. He just thought the ends justified the means. I thought that was a real breach of judicial ethics, but he said that's easy to say now when we don't know who was going to win World War II. A related question is about the Holocaust, and one thing I was never really able to nail down was whether Frankfurter ever confronted Roosevelt about trying to let more Jewish refugees into the United States. Frankfurter did a lot of things to try to get more Jewish refugees in the United States. He protested to Secretary of State Cordell Hull. He arranged a meeting between Justice Brandeis and Hull. He also, his good friend Francis, oh my gosh, the Secretary of Labor.
Perkins.
Thank you, Jeff. Senior moment. Francis Perkins was in charge of immigration at that time, and he lobbied her to let more Jews in the United States. I think Frankfurter knew that FDR was a conflict avoidance person, and confronting FDR about letting more Jews in was not a good strategy. So I think Frankfurter went around him. Ellen Heller asked about Jan Karski, who was someone. There's been a great play about this where David Strathairn plays Jan Karski, and he's on the Shoah documentary, and I've watched all the Shoah outtakes. Jan Karski went in a uniform, a military uniform, and saw the concentration camps inside Poland, and then came to the United States and was reporting to American officials about the atrocities. And he claims that when he went to see Frankfurter, and then he went to see FDR, I think during the summer of 1942, and he says, or maybe it's 43, and he says that when he went to see Frankfurter, Frankfurter said, "I don't believe you." And I think if you look at the entire outtakes, Frankfurter said, "I can't." It was almost like Frankfurter couldn't believe him because the details of the atrocities were so horrific. But Frankfurter had been receiving information from the Polish government. I found it in his files 6 months before his meeting with Karski. So I think he knew on an intellectual level what was happening to Polish Jews, that they were being shipped off to concentration camps. It was the gruesome details that Karski told him that he didn't want to believe because they were so horrific. So I think that meeting really gets misconstrued. And Karski is an incredibly dramatic and moving speaker. And I just think, like many things, a little context shows that Frankfurter was well versed on what was happening in the Holocaust and did almost everything in his power to try to bring as many Jews as he could to the United States.
That's great. We have two questions on the challenge to judicial independence in Israel and what Frankfurter might have thought of that.
Yeah, I mean, obviously, I'm not an expert on what's going on in Israel right now, but I think Frankfurter would be horrified, right? That Frankfurter believed in an independent judiciary to his core, right? He thought that all justices should be above politics, and that I think he violated that rule himself sometimes, but he really didn't like it that William O. Douglas had designs on being president of the United States while sitting on the Supreme Court. And if he had an enemy on the Supreme Court, it was William O. Douglas. He saw Douglas as campaigning to be Roosevelt's vice president in 1944, and he almost was, and then wanting to be president again in 1948. So Frankfurter believed that a judiciary should be independent. I think he would be horrified by what Netanyahu's trying to do to the Supreme Court of Israel. And I think Frankfurter was not on board 100% with Roosevelt's court packing plan. And just, Jeff, one last thing on court packing, right, which was really a challenge to the independence of the judiciary. I was really struck because I know you're an expert on Brandeis, how much that fractured the Brandeis-Frankfurter relationship. I think the thing in my book that was really surprising to me was how they almost stopped being friends after a lifelong friendship, united in trying to promote free speech, trying to promote a Jewish state, and that the Roosevelt's court packing plan almost ended their relationship because Brandeis was upset that Frankfurter stayed neutral publicly during court packing, and Frankfurter was upset that Brandeis came out publicly against the court packing plan. And I was just kind of shocked at the rift that created. And I think Brandeis refused to leave the court to make room for Frankfurter, and that it was no coincidence that Brandeis retires a week after Frankfurter joins the bench. He refused to allow the young New Dealers in the Roosevelt administration to push him off the court in favor of Frankfurter.
You note that Brandeis balanced his devotion to judicial restraint and avoiding constitutional questions with a distrust of federal power and a devotion to states as laboratories of democracy. Arguably, Frankfurter's greatest legacy was his role, which you note so powerfully, as a ghostwriter to FDR, who wrote Franklin Roosevelt's speech on the 150th anniversary of the Constitution, where Roosevelt, using Frankfurter's words, called the Constitution a layman's document, not a lawyer's contract. What would you make of the case that Frankfurter was really the architect of the vision of New Deal constitutionalism that legitimated the modern administrative state? And to the degree that conservatives on the court today are trying to repudiate that vision, it's really Frankfurter's vision that they're repudiating.
I think you're 100% spot on. I love that line from that speech. It's a little hard to tell which portions of it Frankfurter wrote and which portions of it Tom Corcoran wrote, but certainly they were allies at that time. Jeff, you bring up like probably the best question right at the end. I think Frankfurter would be horrified by the way the court is and Hugo Black would be too, at this idea of a major questions doctrine that the right wing of the court is using to dismantle the administrative state. That is not in the text of the Constitution. I think Frankfurter would point to two 1935 cases, Schechter Poultry and Panama Refining, where the court used something called the non-delegation doctrine, where the conservative Supreme Court said Congress was delegating too much of its legislative power to the executive branch. I think Frankfurter would say this is 1935 all over again, and we fought that battle and won, and that the Supreme Court of the United States, the current one, should be more respectful of precedent and learn the lesson of the 1937 New Deal constitutional crisis, as he did, as Hugo Black did, and as the nation did. And I think we're taking a backward turn, really constitutionally, and that it's up to people writing in publications like the New Republic and elsewhere to call the court out for trying to roll back the administrative state, which is one of the most important innovations of the 20th century.
So powerfully put, Brad. Really, it's arguable that there have been 4 republics in America: the founding Reconstruction, the New Deal Republic, which Frankfurter was a central constitutional architect of, along with FDR, and we're now on the cusp of a new one, the Originalist Republic, which is trying to repudiate Frankfurter's New Deal legacy and resurrect an originalist constitution. People disagree, of course, about whether or not that's a good idea or constitutionally rooted, but you've performed a central role in helping us understand Frankfurter's towering constitutional significance as the architect of the republic that is crumbling before our eyes. I'll give you the last word, of course, and I just want to thank you for illuminating Frankfurter so much and reminding us of the central importance of his legacy.
Well, I just want to thank you for asking terrific questions, for everything you've written in the past on Brandeis and Frankfurter. And I just want to add one final note. I was reading a review of an old biography of Hugo Black, and somebody wrote in the New Republic that more needs to be written about the jurisprudence of Hugo Black, namely his emphasis on text and history, and that person in that review was Jeff Rosen, and I just I just said, oh well, there he is. He's everywhere, and so I've benefited so much from your work on both your books, your scholarship, and your writing in the New Republic, and just want to thank you for spending the time to just have such a high-level conversation with me about Felix Frankfurter and constitutional law.
Thank you, Brad. Thank you, Otis and Bethel friends. Such an honor to be with you, this great community, so devoted to learning and light in the Jewish tradition of Frankfurter and Brandeis. It's wonderful to be with you, and we'll look forward to more learning together soon. Thank you all. Thank you, Robin and Marge.
That was so informative, so thought-provoking, and so enriching, and we are in your debt. We're just very grateful. I'm going to ask two quick questions. One is, Jeff, since you wrote a book about RBG, did she ever say anything about Frankfurter passing her over for a clerk, or anything about Frankfurter?
Yes, she actually frequently mentioned that Frankfurter passed her over for a clerkship. She was not happy about it at all. She believed that one reason was that he really liked salty language, that he felt that his sharp cursing would not be appropriate for a woman, which he thought was paternalistic and outrageous. And as Brad mentions in his book, Frankfurter came to see passing over RBG as one of his great mistakes.
Yeah, I mean, I don't know if Frankfurter realized it, Jeff, but I had the privilege to see RBG in her chambers for a few minutes, and I showed her the recommendation letters that Al Sachs had written on RBG's behalf to Frankfurter, which I don't think she had seen before until I showed them to her. And she, even Al Sachs's letter recommending RBG just reeked of what she called, 1950s paternalism and chauvinism. And it was a thrill to be able to ask her about that. And I even asked some of Frankfurter's co-clerks about that, and they knew RBG and lobbied with Frankfurter to hire her. It was a huge mistake. And what's more shocking is to hire the first African-American law clerk in 1948 and not be willing to hire what I think would have been the second woman law clerk. Imagine just how RBG would have enriched Frankfurter and his legacy. It was a true blunder on his part.
Someone will have to write a novel about that.
Yeah.
The only other thing I'll ask you both is, so what do you think, each of you, are the big takeaways that we should know about Frankfurter, the pros and cons, when we leave today?
Well, Jeff, do you want to go first, or do you want me to go first?
Brad, I'll just sum up quickly and pass it to you. The pro, as Brad has so powerfully argued, is that this is the architect of our modern liberal order, which is being challenged on the Supreme Court today. And Frankfurter reminds us of the danger of callously ignoring precedent in the name of a rigid understanding of text and history, which can lead to democratic backlashes and harm the fact that, as Frankfurter put it, liberty is protected in the hearts and minds of people through the democratic process, and the court acts foolishly when it attempts to substitute its own formalistic visions for that of the people themselves. But Brad, I'm sure, how would you put it?
Yeah, in a similar way, I think Frankfurter thought that the Supreme Court, in aggrandizing so much power, was actually undermining our democracy. And in effect, that all of our major political decisions are being outsourced to the Supreme Court of the United States, and that causes our democratic process to atrophy. I think both the left and the right are guilty of trying to take a shortcut of resolving all of their problems, whether it's affirmative action, abortion, what have you, by saying, well, let's just find 5 votes and we can resolve this problem, rather than going through the democratic political process to really resolve some of these issues. And I think Frankfurter really saw the Supreme Court as one of 3 co-equal branches of government and particularly in interpreting the Constitution. And he would be horrified with the kind of one-way ratchet, to use a term of Justice Brennan's, of the Supreme Court's power, right? Since Baker versus Carr, that the Supreme Court has just continually aggrandized its own power. He would say he would not be surprised by all the democratic convulsions that we've had in recent years, given that the way the Supreme Court has become this prize to be won, and then to make changes through this prize to be won, rather than winning through legislative gains like the 64 Civil Rights Act, the 65 Voting Rights Act, and in more recent times, the Affordable Care Act.
Well, thank you. Thank you both for those thoughtful responses and for such a thoughtful conversation. We will be eagerly awaiting, your future projects and publications.